This is People of the State of Michigan versus Katie Austin Lee, case number 25-47529-FC. Today is the date and time scheduled for a plea. Your Honor, the plea agreement is as follows. If the defendant enters a plea to amended count 1, which is second-degree murder, count 2, which is assaulting, resisting, or obstructing a police officer, and added count 3 of torture. There's also a sentence agreement, Your Honor, that the defendant, if the plea successfully goes through, would serve a minimum of 60 years in the Michigan Department of Corrections.
That is a correct statement, Your Honor.
Thank you. Ma'am, would you please stand for the date administering the oath and raise your right hand, please? Do you solemnly swear or affirm that the testimony you are about to give will be the truth?
Yes.
And you may be seated right there, ma'am.
May I approach, Your Honor?
Absolutely. And if you can move that microphone close to Ma'am, do you understand why you are here this afternoon?
I do.
Have you had an adequate opportunity to talk over this plea procedure with your attorneys before we begin?
I have.
And do you wish to proceed?
Yes.
The named offense in count 1 to which you're going to plead guilty is called second-degree murder. This is a felony which carries with it a maximum penalty of up to life imprisonment. Do you understand the name of that offense and the maximum possible penalty?
Yes.
As pertains to count 2, the named offense to which you're going to plead guilty, this is called resisting and obstructing a police officer. Once again, this is a felony which carries with it a maximum penalty of up to 2 years of incarceration. Do you understand the name of that offense and the maximum possible penalty?
Yes.
And finally, count 3, the named offense to which you're going to plead guilty is called torture. Once again, this is a felony which carries with it a maximum penalty of up to life imprisonment. Do you understand the name of that offense and the maximum possible penalty?
Yes.
I also want you to understand that if you are not a United States citizen, these convictions could result in your deportation from the United States. Do you understand that?
Yes.
Your attorney just a moment ago handed me an advice of rights form. Is that your signature on the bottom right?
It is.
Can you see that?
Yes.
Did you read all these rights with your attorney?
Yes.
Do you understand all of these rights?
Yes.
Do you have any questions about any of these rights?
No.
I want you to understand that if I accept your plea of guilty, you're giving up all of the trial rights that are listed on this document. Do you understand that?
Yes.
And I'm just going to go over these again individually just to make sure that you fully understand what you're giving up. I want you to understand that if your plea of guilty is accepted, you will not have a trial of any kind, and you'll be giving up the following rights that you would have had at trial, including the right to be tried by a jury, the right to be presumed innocent until proven guilty, the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty. You would have the right to have the witnesses against you appear at the trial. You would have the right to question those witnesses against you. You would have the right to have the court order any witnesses you have for the defense to appear at the trial. You would have the right to remain silent during the trial and not have that silence used against you, and you would have the right to testify at the trial if you wanted to testify. Ma'am, do you understand that if I accept your plea of guilty that you're giving up all of the trial rights I just listed for you?
Yes.
The plea agreement, as I understand it, is as follows. It's really in 2 parts. Number 1 is the charging instrument. Number 2 is the sanction. In exchange for dismissing the open murder, which is a first-degree murder charge, you'd be pleading guilty, which carries with it a mandatory imprisonment of life imprisonment without the possibility of parole. That charge will be removed. You'd be pleading guilty to counts second-degree murder, resisting and obstructing, and torture, as I mentioned. And in addition, there's a sentencing agreement that you and your attorneys have apparently entered into, at which case the court would sentence you to a minimum period of incarceration in prison for 60 years. The maximum would be set by the court, and frankly would be 90 years. So the plea agreement is basically, it would be 60 years on the minimum, up to 90 years on the maximum. For counts 1 and 3, they would be concurrent with each other. Count 2 is just a 2-year felony. Do you understand what I've just said?
Yes.
Do you understand that there's a minimum prison sentence that's going to be imposed and a maximum prison sentence that's going to be imposed? Do you understand that?
Yes.
Is that your understanding of the complete plea agreement?
Yes.
Besides the plea agreement, have any other promises been made to you as an inducement that has caused you to enter these pleas of guilty?
No.
Have you been threatened in any way so it's caused you to enter these pleas of guilty?
No.
I want you to understand that if I accept your pleas of guilty, you are giving up your right to claim that these pleas were a result of any promises or threats that were not disclosed at this hearing, or that the decision to plead guilty was not given of your own free will. Do you understand that?
I do.
Are you pleading guilty freely and voluntarily?
Yes.
Are you pleading guilty because you are in fact guilty?
Yes.
Regarding count 1 second-degree murder, how do you plead?
Guilty.
Count 2, resisting and obstructing a police officer. How do you plead?
Guilty.
And finally, count 3, how do you plead to charge of torture?
Guilty.
Is it true that on or about February 21 of 2025, you were in Holland City, Ottawa County, Michigan?
Yes.
Okay. And you are the mother of Austin, correct?
I am.
And on that date, he was 17 years old, a minor?
Yes.
And did you administer a drug or a sedative to him?
I did.
As a result of administering that drug or sedative to him, was he unable to have control over his body?
He was.
I'm sorry?
Yes.
So you administered a drug and thereby he no longer had physical control of his body, is that true?
True.
And then you then exercised physical control over his body, is that fair to say?
Yes.
And while you had him under your control, did you intentionally inflict severe mental pain or anguish on him?
Yes.
And did you administer a mind-altering substance to him?
Yes.
And that was done deliberately?
Yes.
And by the administering of that mind-altering drug, did that disrupt his sense of personality, his senses or personality?
Yes.
You then, is it true that while he was under your control and unconscious, that you then had a knife? Is that true?
Yes.
And did you cut his arm on at least 2 occasions?
Yes.
And then did you also use that knife to slice his throat?
Yes.
As a result of you slicing his throat, did that result in his death?
Yes.
And ultimately, you actually called the police at some point in time, is that true?
Yes.
And the police arrived, is that true?
Yes.
And they encountered you still had possession of the knife, true?
Yes.
Did they order you to drop the knife?
Yeah.
Did you immediately comply with their request to drop the knife? In fact, they ultimately had to use a taser, some force on you, is that true?
Yeah.
Okay. Now, as it pertains to the assault on your son, did you have any legal reason or justification in administering him those drugs?
No.
Did you have any lawful reason in using physical force against him?
No.
Mr. Bartholomew, before I proceed further, I note that there was a competency examination that was done of your client earlier, is that true?
That is correct.
And she was deemed competent to proceed with these matters?
Yes, Judge.
As far as criminal responsibility goes, and again, I do not intend to invade the attorney-client privilege, but have you and your office been given an adequate opportunity to explore the criminal responsibility aspects of this matter?
Yes, Your Honor.
Is that something that you are wishing to explore further or not?
Not at this time, Your Honor.
Have you had an adequate opportunity to discuss that possible defense with your client?
Yes, Judge.
And is she on board with the decision to proceed with this plea today?
Yes, Judge.
Do you wish to confirm with her that?
Yes,
was her?
Judge. Ms. Lee, are you satisfied with any type of insanity defense that we pursue during the duration of this proceedings?
Yeah.
And you acknowledge that we did explore some experts in that nature, correct?
Yeah.
And you are ready to proceed today with this hearing?
Yeah.
So, Mr. Bartholomew, may I inquire if your client wishes to not pursue the insanity defense? May I ask her that?
Yes, Your Honor.
Ms. Lee, is it your intention to not pursue an insanity defense?
Yeah.
And just to make sure we understand, the answer matches my question, which is kind of badly phrased. You are not pursuing an insanity defense, is that correct?
Correct.
The court finds that the plea is freely, voluntarily, knowingly made as a factual basis to support the plea. Mr. Bartholomew, are you aware of any promises or threats that have not been disclosed that has caused your client to plead guilty?
No, Your Honor.
Mr. Tuber?
No, Your Honor.
Has the court come out the court rule?
It has.
Mr. Bartholomew?
Yes, Judge.
Ma'am, before I formally accept your plea, this is a very big decision. There's been a lot of decisions that have been very important. This is the next big decision that is affecting you for a long period of time. You understand that once the court accepts your plea, and accepts it, you're going to be serving 60 years in the Michigan Department of Corrections. You understand that?
I do.
And you're in your early 40s right now?
Yes,
So you wouldn't be eligible for parole until, you're over 100. You understand that?
I do.
Before I accept your plea, do you wish to have more time to consult with your attorneys about this big decision?
No.
Are you satisfied with the representation that your attorneys have given you in this matter?
Yes.
Do you wish me to accept your plea?
Yes.
The plea is accepted. Sentence is going to be on December 15, 2025 at 10 o'clock in the morning. If either side wishes more time, I will certainly grant that. Defendant's remanded.
Your Honor, could we do early January or mid-January? I will be out of the office, definitely would like to be here for that.
January 19,
Perfect.
January 19, 2026 at 10 o'clock in the morning. Defendant's remanded. Anything further that needs to be brought before the court?
I don't believe so, Your Honor.
No,
We are in recess.
Thank you.
Okay, may we participate in the PSI, Your Honor?
Absolutely.